repeating a little bit what Senator Lee just said. For the last several years, the other side has ratcheted up the political rhetoric against conservatives and other countries in our country's democratic institutions. More recently, they've directed their focus and ire on the U.S. Supreme Court. They've dubbed the Supreme Court as a MAGA court. They've referred to the current member makeup as somehow radical. The Senate Democratic leader threatened to release a whirlwind, as you know all about that statement. Unfortunately, this has all come as a tremendous cost. Justices and their families have endured ongoing picketing outside of their homes, scenes of public intimidation, harassment, and now death threats. Needless to say, this is all totally unacceptable. So to you, Professor, does America have a MAGA Supreme Court, and how would you describe this characterization?
Well, I mean, we have a Supreme Court, and I agree with a lot of what the senators have said and Chairman Graham, where I believe every justice on the Supreme Court is trying to carry out what they believe their constitutional duty is. It's coming under unprecedented attack, which we have not seen, in many years, with breaches of confidentiality across the branches, people facing attacks and threats. And I think it's our, duty here testifying today and setting these actions to do what we can to make sure that they're portrayed in an accurate light and be careful and studied with what they talk about. With respect to this current decision, as you know, the Supreme Court doesn't reach out to take cases. It takes the cases that come to it. And what prompted this was really the unprecedented nature of the criminal prosecution in this case of the current administration prosecuting a current political rival.
Okay. Judge Mukasey, could you briefly describe how the recent Supreme Court presidential immunity case builds upon previous legal precedent and doesn't give the president the authority to have political enemies terminated?
Well, as I pointed out, there is Nixon against Fitzgerald established the principle that there are immunity principles that apply to the presidency. This is a logical extension or plausible extension of that decision. Marbury versus Madison pointed out that the decisions of the president are not subject to examination by the courts. The notion that somehow the president is immune from prosecution for imagined acts, I think is way beyond what the majority said. Just to offer a less dramatic, but nonetheless equally far-fetched example, if the president, as commander-in-chief, ordered the military to shoplift a tie that he wanted to wear to deliver the State of the Union address, that would not be something that is for which there is immunity. Yes, he's commander-in-chief of the armed forces, but shoplifting is not among the prerogatives that he has to order.
Judge Mukasey, can you briefly explain some other attempts to exert political pressure on the judiciary and what was the results of those?
Well, there have been, as was pointed out, there have been threats to limit the budget of the judiciary. There have been threats to strip the judiciary of its jurisdiction, and I think those are very dangerous, and ultimately will wind up damaging the liberties of all Americans.
Professor Mascott, broadly speaking, can a federal statute overturn a constitutional interpretation by the Supreme Court, or would a constitutional amendment likely be required?
Well, in our system, we treat the interpretations by the Supreme Court as a final judgment. So a federal statute, no, would not overturn it. You would need a constitutional amendment, and that's intentional because of the high bar that it takes with the support of 3/4 of the states to be able to get a constitutional amendment, to be able to override previous understandings of the Constitution.